Welcome to the Compliance 911 Show, a no-nonsense podcast discussing hot topics for today's busy compliance professional. It's everything you wanted to know about regulatory compliance, but we're afraid to ask. And now, here are your hosts, Dean Stockford of M&amp Consulting and Len Suzio of GeoDataVision.
So Len, it's great to see you. What interesting topic do you plan to discuss in today's podcast?
Well, Dean, a couple of episodes ago, I spoke about disparate impact. That's perhaps the hottest regulatory compliance topic these days since President Trump issued Executive Order 14281, called Restoring Equality of Opportunity and Meritocracy, and which seeks to eliminate the use of disparate impact liability in all contexts to the maximum degree possible. There are important legal implications to be sure, but there are also some practical policy and regulatory risk management considerations. I want to discuss the legal implications and talk also about the regulatory compliance policy and practices implications.
That ought to be interesting, Len. So I guess I would say, where do we start?
Well, let's start with the legal issues. There's a history of cases regarding disparate impact that have been settled by the Supreme Court. Back in June of 2015, the court issued in its, quote, inclusive communities, end quote, decision, which upheld the disparate impact theory with respect to the Fair Housing Act. So the court has opined that disparate impact theory is constitutional, at least insofar as the Fair Housing Act is concerned. But in that decision, while upholding the concept of disparate impact, the court imposed significant limitations on the application of disparate impact theory in practice. Basically, the court said a plaintiff may establish liability without proof of intentional discrimination if an identified business practice has a disproportionate effect on certain groups of individuals, and if the practice is not grounded in sound business considerations. The court, however, imposed important limitations on the application of the theory, quote, to protect potential defendants against abusive disparate impact claims, end quote. In particular, the court held that a racial imbalance without more cannot sustain a claim. It said that there must be a, quote, robust causal connection between the challenged practice and the alleged disparities. Now, notice that the disparate outcomes themselves are not sufficient to sustain a claim of discrimination. There's got to be a practice identified that causes disparities. I also point out that the court's decision applied only to the Fair Housing Act. It did not reference the ECOA, the Equal Credit Opportunity Act, which is certain to be affected by Trump's Executive Order 14281. It's highly likely that even if the Trump administration doesn't prosecute potential disparate impact cases, state attorneys general in the so-called blue states will do so. Now, the Biden administration and the prudential bank regulators relied heavily on disparate impact theory in at least 24 redlining cases referred by the prudential bank regulators to the DOJ for prosecution. As a number of legal observers pointed out at the time, the limitations on the application of disparate impact liability imposed by the court would need to be tested by a litigant willing to go all the way against the DOJ. And who would be willing to take that challenge on? So we have jurisprudential history regarding disparate impact in which the Supreme Court recognized it as a legitimate subject to significant limitations, but which limitations were treated lightly by the prudential bank regulators and the DOJ as a prosecuted lenders for alleged redlining. All of those cases were settled before reaching the Supreme Court, so the court-imposed limitations cited in inclusive communities were not fully tested all the way to the final arbiter, the Supreme Court itself. So to summarize or reiterate, we have a Supreme Court decision that accepts the theory of disparate impact as applied under the Fair Housing Act, but with significant limitations. And we have a history of cases prosecuted by the DOJ, which appeared to pay lip service to the limitations applied by the court and which were settled before reaching the Supreme Court itself. Furthermore, disparate impact is applied under the ACOA remains to be decided by the court.
Wow, it sounds certainly to me like a messy situation when you start talking about disparate impact theory, disparate treatment, overt discrimination. Holy smokes, where do we go?
Yes, yes, it's a real mess. And
Yeah.
the Trump administration's decision to limit disparate impact as much as possible only adds to the uncertainty. We will need the lawyers and the courts to sort out the situation, and that could take a few years. The legal ambiguities notwithstanding, there are policy aspects and practical issues to be considered.
Okay, I'm game. What are the policy implications and what might the practical considerations be that you are referring to?
Well, Dean, as much as you would think that inclusive communities settled the matter, at least insofar as mortgage lending and the Fair Housing Act are concerned, cases prosecuted by the DOJ subsequent to inclusive communities demonstrate that the regulators and prosecutors can interpret a Supreme Court decision in their own way. You might consider it to be regulatory abuse by the regulators themselves. But when the regulators have the power of the government to prosecute any lender based on almost entirely statistical analysis without the robust evidence linking specific lending practices with disparate outcomes, almost no one is going to go all the way. The history of how regulators and the DOJ pursued potential disparate impact crimes under the Biden administration demonstrates regulators under a liberal administration are willing to flout the inclusive communities ruling. The situation may be a reason why the Trump administration has made disparate impact a high profile issue. Lenders are caught in a situation in which policies from one presidential administration are the polar opposite of the preceding administration. You might say that bankers should complain about disparate impact of radically changing of the radically changing and volatile regulatory environment itself. But the reality is that from the Obama administration to the Trump administration, and then back to the Biden administration, and now back to the second Trump administration, shows that the regulatory environment enforcement pendulum has swung wildly back and forth. The lesson learned is that regulatory enforcement does not require legislative action, nor does it necessarily require changes in the regulations themselves. It's easy from one administration to the next to change how regulations are interpreted and enforced simply by making changes to the examiner manuals. It's a situation conducive to wild swings in regulatory compliance policies and practices. But it's the reality in which today's regulatory compliance professionals must work. Prudence would dictate that while compliance professionals may hope that aggressive fair lending enforcement based on disparate impact theory will not only not be pursued by the Trump administration, but by subsequent administrations as well. But those compliance professionals should act knowing that any administration could resume the aggressive use of disparate impact theory simply by just changing the examiner manuals.
Yeah, that is absolutely correct. And we've talked about that several times. It certainly have encouraged compliance officers not to be complacent and remind them that their administration's only there for about 4 years, and then you have another change in administration. So, and who knows what that will look like. So let me say this, in light of what's a compliance, what should I should say, a compliance officer or professional to do? I mean, what's your advice, Len?
Well, my advice might be surprising, especially in light of the Trump administration's attack on the application of disparate impact theory. I strongly recommend that lenders continue the use of disparate impact analysis to determine if their lending patterns reflect racial, ethnic, or gender differences that are so extreme as to be statistically significant. You see, while the legal aspects of disparate impact theory need to be worked out, disparate impact analysis is nevertheless a useful analytical tool to identify results that are so different in impact on protected class groups that they invite a deeper analysis to determine one, if the disparities are caused by a lender's practices, product offerings, or policies, or two, whether the disparities are related to independent factors in the market in which the lender is operating. Every lender should be making a good faith effort to ensure it is not unintentionally engaging in discrimination, and disparate impact results is an indicator that something isn't right. In other words, while the legal issues remain to be settled, The practice of using statistical analysis to identify potential extreme disparities should continue as a risk management tool. The legal issue is related to, but separate from, the use of disparate impact as a legitimate analytical tool. Now, I know some compliance professionals may be concerned about, quote, self-incrimination, but a bank that employs disparate impact analysis is demonstrating a good faith that it is making an effort to detect any possible discrimination in its lending practices. If the bank does discover disparate results, best practice would dictate that it followed up to isolate the cause or causes of such disparate results. If the bank discovers lending disparities and determines they are related to the bank's policies or practices, it should make corrections in policy, or it should develop a written explanation as to why the policy or practice is needed. And by the way, this is consistent with inclusive communities. On the other hand, if the bank discovers that disparities are related to external market factors, then the bank should document that finding in a written report to the compliance committee or board. I'm not suggesting this is legal advice, being neither you nor I are lawyers, but I do believe that this is consistent with best practices for compliance professionals.
Yeah, so you think disparate impact is not going away no matter the legal outcome, and that disparate impact established by statistical analysis is a legitimate and practical tool that compliance professionals should employ in their compliance risk management systems. And I would agree with that advice, Len.
Yeah, and that's really a good summary of what I'm suggesting, Dean. Compliance professionals have to be prepared for an unknown legal future for disparate impact theory. But whatever its legal status, disparate impact, as established by statistical analysis, is a legitimate indicator of potential discrimination, not proof of it. And as such, it should be a part of the compliance toolbox for any compliance risk management program.
Well, I know you always say you like to have provocative discussions. Len, I think you accomplished that today. This is Dean Stockford of M&M Consulting.
And this is Len Suzio of GeoDataVision saying, we hope you enjoyed today's podcast and learned something from it. We encourage you and invite you to send us any requests you may have for future podcasts.
Thanks for listening to the Compliance 911 Show. If you like the podcast, be sure to subscribe so you don't miss an episode. While you're at it, please give us a like and review to help others find the show. As always, links are in the show notes, and you can always find us online at compliance911show.com. Follow M&M Consulting and GeoDataVision on LinkedIn for all the latest news and information on compliance hot topics.